Well, I think the Supreme Court of Pakistan has correctly observed and held that the Election Commission of Pakistan cannot disqualify a parliamentarian under Article 62(1)(f. And this is consistent with the language of Article 62(1)(f, which says that a person can only be disqualified in terms of that article where there is a declaration by a court of competent jurisdiction. And let us not forget that the Election Commission of Pakistan is not a court. Numerous judgments of the superior courts of Pakistan, of multiple high courts, of the Supreme Court have held that the Election Commission of Pakistan is not a court of law. So as a result, the Supreme Court of Pakistan's holding that the Election Commission of Pakistan could not have declared a person to be disqualified in terms of Article 62(1)(f, that holding is correct. Moreover, the Supreme Court also talks about the Islamabad High Court judgment where the Election Commission's decision was upheld. The Islamabad High Court, in upholding that decision, relied on a judgment from 2018 in the case of Habib Akram, where the Supreme Court had held that there shall be consequences if a person makes a misdeclaration on his nomination papers. Now, the Islamabad High Court held that in terms of that judgment, the consequence of that misdeclaration is that Faisal Vawda stands disqualified. And as a result, there is no need for any declaration by a court of competent jurisdiction. However, that judgment, the Habib Akram judgment from 2018, says that when a person misdeclares or makes a misdeclaration in his nomination papers, there shall be consequences in accordance with the law. Now, what is the law? The law, as found in Article 62(1)(f, says that if you believe that a person has been dishonest or is untruthful, then you may approach a court of competent jurisdiction and seek that person's disqualification in terms of Article 62(1)(f). Now, to this extent, I am in agreement with the Supreme Court's judgment, and I think the law laid down by the Supreme Court is consistent with the principles of our Constitution. Having said that, I believe the Supreme Court goes one step further. The Supreme Court also says that this declaration was erroneous. The declaration that Mr. Faisal Vawda was not a dual national, or that he was only a Pakistani national at the time of submitting his nomination papers, the Supreme Court holds that this was an erroneous declaration. And as a result, the Supreme Court also closes the door for somebody else to subsequently approach a court of competent jurisdiction and then challenge Mr. Vawda's qualification in terms of Article 62(1)(f). The Supreme Court, insofar as it holds that this was an erroneous declaration, also closes the door for that. I think that is perhaps an overstep, and I feel the Supreme Court should not have done that. Because in a number of previous cases, the Supreme Court has held that such declarations are not only erroneous, but are also an attempt to conceal information, and are perhaps also an attempt to mislead their voters. So as a result, the Supreme Court should have only set aside the Election Commission's decision, because the Election Commission's decision did suffer from a number of lacunas. So while that aspect of this 4-page judgment is legally tenable, but the Supreme Court, the magnanimity that the Supreme Court has shown towards Mr. Vawda, insofar as the court holds that he merely made an error in his nomination papers, that magnanimity was perhaps not afforded or extended to certain other parliamentarians in the past.